I will briefly introduce regarding rescission, SRA 1950, misrepresentation and undue influence. Rescission is a remedy that enables transactions to be set aside where they are affected at the outset by some vitiating elements recognized in equity. The elements that we will be presenting would be misrepresentation and undue influence. In matters of specific performance of contract, the SRA 1950 is a significant legislation that governs the principles and remedies available.
So in relation of Section 34, subsection 1 of the Distribution Facility Act, it basically lists out conditions in which a rescission could be granted by the courts. One of them being the contract must be in writing, the contract is deemed voidable or terminable by the choice of the plaintiff, the contract has been unlawful where the defendant is deemed more at fault than the plaintiff, and where a decree of specific performance of the said contract has been made, and the purchaser or lessee makes default in payment of the purchase money or sums in which the courts have ordered him to pay. Following that with Section 35, Section 35 provides grounds for which rescission could be granted on basically the reason of mistake. Okay, in this section it's mentioned how rescission could not be granted by the courts for contracts in writing for the sole reason of mistake, unless the party whom the rescission is against could be restored back significantly back to his pre-contractual state. And in Section 36, the general gist of it is that the plaintiff that is going for the suit of specific performance could actually at the same time pray for the remedy of rescission of the contract should specific performance be impossible or not able to be carried out by the court. And also under Section 37 provides that the court would actually require the party who prays for a rescission to be ready to act equitably to the other party and actually compensate the other party for any benefits that they might have gained during the time of the contract, during the duration of the contract. So basically, it's kind of touching on the maxim of he who wants equity must do equity. The case that I'm going to refer to is the RHB Bank Berhad against Travel Site Sahira and Berhad. The main issue was basically a dispute over rescission of a purchase agreement and subsequent rights to property and refund of the purchase price. In the judgment, the court ordered that the liquidators pay the refund to Travel Site as RHB has been repaid and rescission was granted on the basis that mutual restitution was not fulfilled by the liquidators who refused to refund the purchase price yet claimed the property. This conduct was found to be unconscionable and in breach of the duty imposed by equity to account. So basically the same maxim applies of he who wants equity must do equity. So they had to compensate back and basically not void the contract, but just cancel the contract. It's no longer in existence.
So, in this case, the Court of Appeal held that damages should be assessed on the basis of rescission and not breach of contract. This is where the plaintiff was entitled to recover all expenditure reasonably and properly incurred due to the defendant's fraudulent misrepresentation. However, there are certain items such as loss of rent were deemed irrecoverable as they amounted to damages for breach of contract, where the court also found that the cost of the valuation report was not a reasonable expense and therefore it is irrecoverable. So basically, in this case, the Court of Appeal had highlighted few principles in order to apply for rescission, which is the first one. Rescission is a specific relief and it is available only as a self-help, and if there is agreement on satisfaction on certain condition which is agreed by both parties. Second, rescission is invented during Court of Chancery and now it is placed in the Specific Relief Act, so it is there. Third, if the plaintiff apply for rescission, it has the effect on the contract as void ab initio and not obligations de futuro, which means the contract will void from the very beginnings and there is no obligations for the parties to conduct in the contract. Next, if the rescission is granted, it will places back the parties back to its original place. And lastly, in this case, the rescission is granted, the future obligations and true rescission will count as two both different acts. So basically, this case plays a very vital role in order for rescission in a contract.
From the facts in the case of Yap Bun Hua and Ki Wah Sung, there are three main principles followed from the case of Abdul Razak to the context of rescission in fraudulent misrepresentation. The first principle is existence of fraudulent misrepresentation. The foundational principle is the establishment of fraudulent misrepresentation. The aggrieved party must demonstrate that the other party had made false statement or concealed material facts with the intent to deceive the defendant. In the Yap Bun Hua case, the plaintiff alleged the second plaintiff induced the defendant to sign a joint venture agreement with promise of profitable project that were never executed. The second principle is entitlement to rescind the contract. The aggrieved party has proven fraudulent misrepresentation and must be entitled to rescind the contract. Rescission involves the cancellation of the contract and a return to the pre-contractual position. In this present case, the plaintiff sought to cancel the share transfer and return to the status quo before the alleged misrepresentation occurred. Lastly, claim for compensation. Abdul Razak case emphasized that the aggrieved party is entitled to claim compensation for actual and consensual losses. This aligns with the damages sought in Yap Bun Hua case, where the court ordered the defendant to pay 300,000 for the Nada Mewah shares and additional damages for losses flowing from the misrepresentation. In conclusion, the principle outlined in the Abdul Razak case provide a comprehensive guide for assessing damages in a rescinding contract in case of fraudulent misrepresentation. The application of this principle ensures restoring the aggrieved party to the position they would have occupied if the misrepresentation had not occurred.
This case shows the transaction is tainted by undue influence. It is avoidable not only between the parties and their privates, but also against other person who said they enforce the transaction with actual or constructive knowledge or notice that it was procured by their undue influence or any other vitiating element. In other words, a third party may securely take under the enforce such a transaction only if he gain purchaser for the value without knowledge of the disqualifying facts. Section 26, subsection B of Specific Relief Act expresses the notion of the bona fide purchaser for value without notice in the context of specific contract enforcement. The case of Tengku Abdullah bin Sultan Abu Bakar and Muhammad Latif bin Shah Muhammad decision established of standard for rescinding a contract owing to undue influence in the future cases.
Next, we take a look at the recent Malaysian case that apply the principle of undue influence in order to rescind certain particular contract, which is we can see in the case of Zahari bin Zainal Abidin against Juliah binti Muhammad Hassan. In this case, it involves a dispute over 45 million ringgit estate. Puan Hasnah, who is the late plaintiff's mother, claimed a share based on the CJ Faraid, while the defendants argued that Puan Hasnah had already assigned her rights through a contract. The main issue that it revolved around was Puan Hasnah's mental capacity when signing the agreement. If she wasn't suffering from Alzheimer's disease at the time, the focus shifts to whether the defendant unduly influenced her due to her old age and her disease. The court examines whether the assignment is unquestionable, with the defendant having the burden to prove no undue influence. Referencing to Tengku Abdullah case, the court stressed out following legislative tests in assessing undue influence. The first one is the respondent use their position to dominate the will of others and use that position to obtain an unfair advantages over the appellants. Second principle is the appellant cancels a contract because of material breach by the appellants themselves through to have undue influence over the club. And the last principle from Tengku Abdullah case is the appellant must prove that there was a fiduciary relationship between appellant and respondent. Ultimately, the court found that defendant failed to meet their requirements, which is lack of evidence. Wan Hasna's permanent Alzheimer's condition led to the claim that the assignment was unconscionable, placing the burden on the defendant to prove no undue influence, which they failed to do so. As a result, the court ruled that the committee overseeing Wan Hasna's affair could rescind the agreement under proviso that had been provided under Section 60 of Contract Act 1950. In summary, to conclude, the court considered the proviso that stated in Contract Act and previous cases such as Tengku Abdullah case in determining whether any party could rescind the agreement on the ground of undue influence.
Overall, misrepresentation is an important aspect of rescission as a remedy in both law and equity. It serves to protect parties from entering into contracts based on false or misleading information, allowing them to rectify their position and seek appropriate redress when they have been misled. Undue influence serves as a ground for seeking the remedy of rescission, allowing for the cancellation or annulment of an agreement if it is proven that one party exerted improper and excessive influence over another, leading to an unfair transaction. In conclusion, rescission as a remedy under the Specific Relief Act 1950 plays a crucial role in promoting fairness, justice, and accountability in contractual relationship. It protects other parties' protection against the consequences of fraudulent misrepresentation, undue influence or mistake, and seeks to restore equity and balance in the